Hey everyone, welcome back to the channel today. We're breaking down a topic that confuses a lot of advocates. Does GST apply to legal services? Do individual lawyers or law firms need to register under GST? And what does the law, and even the courts, say about this? Stay till the end, because we'll also look at an important Delhi High Court case that clarified this whole issue.
Order! Order!
Let's start simple. Under GST law, legal services are taxable, but not in the usual way. For advocates, the government has specifically provided that the reverse charge mechanism, RCM, will apply. That means if a business hires an advocate or law firm, GST is not paid by the advocate. It is paid by the business, the client, under RCM. If you provide legal services to individuals or non-business clients, then those services are completely exempt under GST. No GST, no registration needed. This isn't new. Back in 2012, under the old service tax law, a negative list regime was introduced. Legal services by advocates were already exempted back then. And when GST came in 2017, the same policy continued through notification number 12/2017, central tax rate. Now, here's where many people get confused. Some say, if my service falls under RCM, I still need to register for GST. That's not correct. Here's the official position. If all your services fall under reverse charge, you don't need to register, even if your turnover is above 20 lakh rupees, because you're not liable to pay tax yourself. Registration is required only if you have other taxable services not under RCM, or you cross the threshold with forward charge services. Let's now look at a key case, J.K. Mittal and Company versus Union of India, decided by the Delhi High Court on the 18th of July, 2017. Here's what the court actually said. Till further orders, no coercive action shall be taken against advocates, law firms of advocates, including limited liability partnerships, LLPs, of advocates for non-compliance with any legal requirement under the CGST, SGST, or IGST Act. And further, all legal services provided by advocates, law firms of advocates, or LLPS of advocates will continue to be governed by the reverse charge mechanism unless any such legal service provider wants to take advantage of input tax credit and seeks to continue with the voluntary registration under Section 25(3) of the CGST Act. In simple words, the court protected advocates from being forced to register for GST. It said legal services will remain under RCM. Clients will continue to pay GST. Advocates need not register unless they want to voluntarily for input tax credit. In simple words, the court protected advocates from being forced to register for GST. It said legal services will remain under RCM. Clients will continue to pay GST. Advocates need not register unless they want to voluntarily for input tax credit. So to sum up, legal services by advocates are under reverse charge mechanism. The client pays GST, and registration isn't needed unless you have other taxable services. Now remember, this was an interim order, not a final judgment. Later, the Supreme Court took up similar petitions and stayed proceedings, so technically, the issue is still pending. But in practice, the RCM system continues, and most advocates still don't need GST registration unless they provide other taxable services. If you found this useful, hit like, subscribe, and share this with your lawyer friends. Because most of them are still confused about GST, follow for more legal tax breakdowns at Accountably You.